Bloomberg Audio Studios. Podcasts, radio, news.
This is Bloomberg Law.
Congress can have no say in making an office independent.
I think all agencies need a degree of autonomy.
It really tests whether the amendments to the law have teeth.
Interviews with prominent attorneys and Bloomberg legal experts.
Joining me is constitutional law professor David Super, Bloomberg News Supreme Court reporter Greg Storr.
And analysis of important legal issues, cases, and headlines.
Apple's a walled garden. They don't license their technology.
That is a valid basis to dismiss the case.
Bloomberg Law with June Grasso from Bloomberg Radio.
Welcome to the Bloomberg Law Show. I'm June Grasso. Ahead in this hour, President Trump's battle with the Fed escalates into an emergency court hearing. Can Trump jail protesters who burned the American flag? And the Supreme Court allows the administration to do what it wants again. It's an unprecedented legal battle that could reshape the Federal Reserve's long-standing political independence. President Trump is the first president in history to try to oust a sitting Fed governor. Trump says he's firing Lisa Cook, the first black woman to serve as a Fed governor, because she committed mortgage fraud by listing homes in both Michigan and Georgia as her primary residences when she got mortgages in 2021.
She seems to have had an infraction, and she can't have an infraction, and especially that infraction, because she's in charge of, if you think about it, mortgages, and we need people that are 100% above board.
Cook is fighting back by filing a lawsuit saying Trump doesn't have the power to remove her from office and that he violated the federal law that allows him to remove a Fed governor only for cause. Cook's lawsuit is a major escalation in the growing clash between the White House and the Fed, which has resisted Trump's demands for lower interest rates. It presents novel issues and will almost certainly end up at the Supreme Court. It's just a matter of when. Cook is seeking an emergency injunction to block her firing and confirm her status as a member of the Fed's governing board. Federal Judge Gia Cobb held an emergency hearing on Friday, but her decision isn't likely until next week, or perhaps even later. Joining me is Bloomberg Intelligence senior litigation analyst Elliot Stein. Elliot, tell us about Cook's arguments for why Trump can't fire her for these mortgage fraud allegations that took place before she became a Fed governor.
Well, the first argument is that the for-cause requirement hasn't been met. And their argument is that cause requires more than mere allegations on Truth Social, that you look to the Humphreys executor standard, which is that there has to be some sort of inefficiency, neglect of duty, or malfeasance in office. These allegations don't rise to that, and in any event, she wasn't given an opportunity to be heard on this and to contest the allegations, and that she has a right to receive notice of the accusations and to contest them.
And is the administration's main argument that basically the president is the president and the courts have to defer to him?
Yeah, that's a lot of it. I mean, their argument first is that the statutory text only refers to cause. It doesn't refer to inefficiency, neglect of duty, or malfeasance in office. So that gives him a broader removal authority. And then there's also nothing in the statute or in the case law, is their argument, that a court can even review that determination, that the statute gives the president the right to determine if there was cause, and that's not reviewable, and that there's also nothing about giving the person notice or an opportunity to be heard. And in fact, the case law, they argue, goes against Lisa Cook's argument on that. And if notice was required, she got notice because she was aware for several days about these allegations before she was actually terminated, and she never tried to rebut the allegations factually. And in any event, a hearing, this is the government's argument, a hearing seems like it would be unnecessary because she hasn't even contested the allegations and given a reason for why these documents would have been filled out in the way that they were.
The only sort of explanation she gave in her papers was that there might have been an unintentional clerical error in her mortgage application. a mislabeling, but no real explanation beyond that. And as far as the administration's claims that Trump's Truth Social posts constituted notice of the allegations, Judge Cobb said to the government's lawyer, "You're not suggesting what happened would satisfy due process requirements." And he replied that he was.
Yeah, their argument is that the Truth Social posts do provide sufficient notice, and as a result, if notice is required, they satisfied it. And Abby Lowell had a sort of funny line. He said, notice shouldn't require having to sign up for Truth Social in order to see the president's Truth Social post directly. And Abby Lowell's argument is, it has to be something a little more formal than that, not necessarily, a full-blown investigation, but some opportunity to rebut the allegations.
In May, the Supreme Court blocked the reinstatement of NLRB and Merit Systems Protection Board commissioners while their suits played out, and did the same for Consumer Product Safety Commission heads in July. So was there an argument that this judge should follow that precedent here?
That did come up in a few contexts, one of which was the irreparable harm argument, because, Lisa Cook's argument is that if she can't continue to serve on the Federal Reserve Board while the litigation plays out, she'll be irreparably harmed because, she's unable to perform her duties that she was appointed and confirmed to perform. And the government cited all these cases, including Wilcox, right, where the NLRB and the Merit Systems Protection Board commissioners were not reinstated by the Supreme Court while those cases played out. And, the government argued those cases stand for the proposition that it's harmful to the president if, he's unable to perform his statutory duties to remove federal officers. The Wilcox case really, it's a good example of how it can be used by both sides to support their argument.
But a different factor here is the independence of the Fed, and that was a highlight of Cook's complaint. Did it play in the hearing as well? Judge
Cobb herself alluded to it. It came up obviously several times in Abby Lowell's arguments as well. And I think, it's relevant because the Supreme Court in May and Wilcox sort of alluded to it in the sense that the Federal Reserve is more of a quasi-private, uniquely structured institution, whereas so much of the case law deals with agencies, some of which don't even exist anymore. The cases are from more than 100 years ago. So the context may be a little different. We'll just see how much that actually matters to the various judges that are going to hear this.
This was an emergency hearing. What turned it into not so much of an emergency?
Yeah, well, where one side seeks a TRO, a temporary restraining order, but they're only good, if they're granted, they're only good for like 10 days, maybe 2 weeks. And then the party has to seek a preliminary injunction in order to basically keep the status quo in place for the rest of the litigation. And what often happens, I think is probably going to happen here, is because the issues are so similar for a TRO and a preliminary injunction, the parties don't want to have to go through the same motions twice. So the way the court left it was that they're going to finish briefing the TRO on Tuesday. Lisa Cook will file her reply to President Trump's papers. And in the meantime, the parties will talk about potentially basically converting the TRO motion to a preliminary injunction motion, again, because the issues basically are the same, and it would just allow the ruling to stay in place longer, and it would allow the ruling to be appealed.
We're at a very early stage of this litigation, but after the hearing, do you think Trump or Cook has the edge?
Well, this is such a close case. I think President Trump has very good arguments based on the text of the Federal Reserve Act, which only says for cause and doesn't say anything more than that. Case law, I think, also in large measure helps President Trump, but you have to overlay over all that. Now we're talking about the Federal Reserve here, and the Supreme Court in the Wilcox decision in May went out of its way to distinguish the Federal Reserve when it comes to a lot of these issues. And so much of the case law that is being discussed deals with agencies that really fall more clearly under executive authority. So it's going to really be up to the various courts that are going to hear this to decide how much they want to distinguish the Federal Reserve from all that precedent. And, I think Judge Cobb alluded to that. She said she has to map Federal Reserve independence over all these issues. To me, that suggests Lisa Cook has a good shot at winning before Judge Cobb, at least at this early stage. And then, from there, we'll go up to the D.C. Circuit and then the Supreme Court, and we'll see how they deal with their Wilcox decision from May.
Elliot, tell us what the Fed's response to the lawsuit has been.
The Fed is sort of staying silent and not picking a side and saying they'll abide by any court decision, which is why Lisa Cook's complaint names the Federal Reserve Board governors both collectively and in their individual capacity as defendants, along with Fed Chair Jay Powell.
Explain why timing might be important for Trump here.
In the near term, you have an FOMC meeting in mid-September, right, where everyone's expecting some sort of rate cuts, it seems. I actually don't think that's the most important date because for that date, Lisa Cook is just one seat on the FOMC out of 12. In July, when they met and they didn't lower rates, you only had 2 dissenting votes. So I don't think her vote is necessarily going to sway anything in September. But to me, the more important dates to keep in mind are the end of February when the Federal Reserve Board gets to reappoint or block reappointment of the regional Federal Reserve Bank presidents who rotate onto the FOMC. So if the president can oust Lisa Cook by February, he essentially on the Federal Reserve Board will have 3 sympathetic votes, and on the other side you'd have 3 votes that probably don't align with the president: Powell, Michael Barr, and Vice Chair Jefferson. And you wouldn't have all these other regional Reserve Bank presidents who, for the most part, have been voting consistently with Jay Powell against lowering rates. So, February is important because it starts to potentially change the composition of the FOMC in a direction that's more favorable to President Trump.
And Trump is continuing to fire board members. On Wednesday, he fired one of 2 Democratic members of the U.S. Surface Transportation Board to break a 2-2 tie before the board considers the largest railroad merger ever proposed.
I think the hallmark of this when the history books are written is its efforts to expand executive authority over almost every aspect of the government. We do have the Supreme Court decision in May that suggested the Federal Reserve is a little different. We'll sort of see how that plays out.
Thanks, Elliot. That's Bloomberg Intelligence Senior Litigation Analyst Elliot Stein. Coming up next, Trump wants to jail flag burners. I'm June Grasso, and you're listening to Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
And what the penalty is going to be, if you burn a flag, you get 1 year in jail, no early exits, no nothing. You get 1 year in jail. If you burn a flag, you get, and what it does is incite to riot.
President Trump signed an executive order on Monday directing the U.S. Attorney General to prosecute people for burning the American flag. But flag burning is protected under the First Amendment under well-settled Supreme Court precedents. In fact, none other than the late Justice Antonin Scalia, a conservative icon, was part of the majority in the 1989 case that established that the Constitution protects burning the flag as a form of symbolic speech.
Yeah, if I were king, I would not allow people to go about burning the American flag. However, we have a First Amendment which says that the right of free speech shall not be abridged, and it is addressed in particular to speech critical of the government. I mean, that was the main kind of speech that tyrants would seek to suppress. Burning the flag is a form of expression.
Trump called the justices who made that decision a, quote, very sad court. And the order directs the Attorney General to pursue litigation to challenge that 1989 precedent.
You get 1 year in jail, and it goes on your record. And you will see flag burning stopping immediately.
But just 2 hours later, a combat veteran burned an American flag across the street from the White House to protest the executive order targeting flag burning.
I'm burning this flag as a protest to that illegal fascist president that sits in that house.
My guest is David Cole, a professor at Georgetown Law. He represented the men who burned the flags in the two leading Supreme Court cases. David, there's a long history in this country of desecrating or burning the flag as a form of political protest that goes back to the Civil War. But states and even Congress have passed laws to prevent flag burning. Tell us about the seminal case the Supreme Court decided in 1989, where you represented Gregory Lee Johnson.
Sure. So Gregory Johnson burned an American flag in Dallas, Texas, in a protest outside of the Republican National Convention that year, and was prosecuted under a Texas statute that made it a crime to burn the flag in a way that would deeply offend onlookers. He was convicted in the trial court. That conviction was overturned by the highest court in Texas, but Texas took the case up to the Supreme Court, and the Supreme Court in Texas versus Johnson ruled that the government may not criminalize expression through the burning of a flag simply because people find that message offensive.
It was a 5-4 decision, but it didn't divide the court down ideological lines. In fact, conservative icon Justice Antonin Scalia was in the majority. Why do you think it didn't go down ideological lines?
So that's a great question. We won the case with the votes of two Republican appointees, Justice Kennedy and Justice Scalia, both of whom I think, over time showed themselves to be committed to the First Amendment. Justice Stevens, also a committed First Amendment justice, dissented. I think in his case, it came down to the fact that he was a veteran of World War II. He clearly was deeply offended by the very practice of burning a flag and therefore dissented. But over time, I think, if you look back at the cases that preceded Texas versus Johnson, many justices, including liberal justices, expressed some reservation about whether or not flag burning should be protected by the First Amendment. So it's not something that has divided the country along partisan lines.
And will you explain the thinking of the justices in the majority and in the dissent?
So the majority held that the justification for throwing someone in jail for burning the flag is that the message sent by engaging in that conduct is offensive. And the court held that under the First Amendment, the government has to maintain neutrality in the field of expression. It can't punish speech simply because it or a majority of people find a particular message to be offensive. Once you go down that road, virtually anything can be prohibited by the government because one man's offense is another man's truth. The dissent argued, well, this is really not so essential a form of expression. Chief Justice Rehnquist called flag burning, quote, an inarticulate grunt, and there's a very powerful interest in preserving the unity that the symbol expresses, and therefore states should be permitted to prescribe how people can use the flag. They can wave it, but they can't burn it.
So President Trump is also with this executive order calling for Attorney General Pam Bondi to pursue litigation to challenge the Supreme Court's ruling in 1989. This Supreme Court is very different from that Supreme Court. Do you think that they would still uphold the precedent?
Yes. This court is different from the court from 1989 and 1990, but this is, if anything, an even stronger pro-First Amendment court. And Texas versus Johnson is not just a kind of one-off. It is cited again and again and again for this basic premise, probably the most fundamental premise of free speech law, which is the fact that speech offends somebody is not a justification for the government to throw the speaker in jail. And that's ultimately what punishing flag burners is about. It's about throwing them in jail because we would be, very pleased if they wave the flag. We are very upset if they burn the flag. But either way, you are using the flag to express a message. And the government is not allowed to tell us what messages we can and cannot express through symbolic speech or otherwise.
Now, Trump's executive order doesn't direct the Attorney General to prosecute those who burn flags for the flag burning itself, but it says the Justice Department should bring cases, quote, against acts of American flag desecration that violate applicable content-neutral laws while causing harm unrelated to expression consistent with the First Amendment. So the cases are going to be limited to those where there's a violation of other laws?
So this executive order is, I suppose, as befitting something that is ultimately about symbols, almost entirely symbolic, because it acknowledges, as it must, that the Supreme Court has decisively ruled that you can't punish someone for burning a flag. And what it does is says, well, there may be some circumstances in which one could, where the reason you're engaged in the prosecution is not the burning of the flag per se, but some other interest altogether. So, for example, many towns and cities prohibit burning of anything in public without a permit. You can't burn leaves, you can't burn wood in public without a permit. That law can be applied to the burning of an American flag because the law is not about speech. It's not about what burning a flag communicates. It's a environmental law or fire safety law that is neutral as to speech. And it's long been the case that that kind of law, in fact, the Supreme Court has said that kind of law would be perfectly permissible. It is very rare that that is the basis for a flag desecration prosecution, however. And the other example that Trump puts forth is, well, if somebody burned a flag in such a way as it constituted incitement to imminent lawless action or fighting words, those are not protected by the First Amendment. Even pure speech, if it constitutes incitement to imminent lawless action or fighting words, is not protected by the First Amendment. So if flag burning fell into those very, very narrow categories, you could prosecute it. That's true, but sort of trivial and largely irrelevant because people burn flags not to engage in fighting words, not to incite some imminent lawless action, but to protest what the American government is doing. That's why they burn flags. And that is exactly why flag desecration laws were enacted, and that, the Supreme Court has held, is an impermissible justification for targeting any form of speech. So yeah, if you come up with a case, and I have not seen one in my entire lifetime, where someone burns a flag in order to send a signal to some group that is steeled to action to engage in illegal conduct, well, sure, just as you could criminalize that person from, raising his hand to incite that lawless action, you could penalize burning a flag if it's being used for that purpose. But it's really a null set. And so I think at the end of the day, Trump's executive order is itself a kind of a nullity. It's a political act. It's not going to have any real world effects. And it's essentially theater engaged in by the president because it's good politics. It's easy to be on the side of condemning the burning of the American flag. That's why Democrats and Republicans have done that for a long time. That's why 49 state legislatures voted to amend the Constitution after Texas versus Johnson and United States versus Eichmann, and the amendment effort only failed by a few votes in the Senate because the easy political act is to condemn these kinds of expressions. The hard thing, the courageous thing, is to protect them even if we find them, and even because we find them detestable and offensive.
A combat veteran burned a flag outside the White House on Monday in protest of Trump's executive order targeting flag burning. He was detained by Secret Service for igniting an object, then turned over to the U.S. Park Police and arrested. He was issued 2 citations, not for burning the flag, but for setting a fire in an unsecured place and for damaging park property. Does he have a defense that he's being selectively prosecuted, or is that, a straightforward citation?
So I think in the absence of Trump's executive order, it would be a straightforward citation. That is, of course, the federal government is permitted to ban burning things on federal property, and it can ban burning flags along with burning leaves or anything else on federal property, and that wouldn't raise a serious First Amendment objection even if someone burned a flag for protest. But now that Trump has issued this executive order and basically announced, as the President of the United States, I am directing the Justice Department to prosecute flag burners. Why? Because flag burning expresses an offensive message. That essentially gives this protester evidence of selective prosecution. He can introduce as Exhibit A in his defense the fact that the president announced the day before he was arrested that the government would target people who burn flags using other laws, but doing so because the president disapproves of the message that is sent. And so he now has a defense that he wouldn't have had the president not issued that executive order.
And he already has a lawyer and says he welcomes the legal challenge. Thanks so much, David. That's Georgetown law professor David Cole. Coming up next, the Supreme Court hands Trump another victory. I'm June Grasso, and you're listening to Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
I order the end to all of the lawless diversity, equity, and inclusion nonsense policies across the government and all across the private sector and the military.
President Trump has tried to wipe out diversity, equity, and inclusion programs in both the public and private sectors. And early this year, the National Institutes of Health began terminating thousands of medical research grants that don't align with the president's policies on DEI. More than a dozen states, researchers, universities, and public health organizations sued, saying the cuts would set back crucial research by years, if not decades. They won at the district court level and at the appellate court level. But the Supreme Court, in a 5-4 decision, sided with the Trump administration, clearing the way for it to cut nearly $800 million in medical research grants, while legal battles over the funding play out in the lower courts. Joining me is constitutional law expert David Super, a professor at Georgetown Law. David, what kinds of grants were cut here?
The administration canceled thousands of grants the NIH had provided for research on a wide range of topics. Ostensibly, these grants were cut off because they related to diversity, equity, and inclusion, or because they related to gender or gender identity as understood by the administration. In fact, it took little more than having the word diversity or equity in the name of the project to get it cut off. Some projects that had nothing to do with race or racial equity or racial inclusion were cut off, but the district court found that disproportionately research into health problems that affect people of color were targets of this cutoff.
Federal Judge William Young, a Reagan appointee, said following a bench trial, this represents racial discrimination and discrimination against America's LGBTQ community. I would be blind not to call it out.
Yes, he also found that the cutoffs showed remarkable insensitivity to the health problems affecting women.
In the past, have administrations cut off grants for arbitrary reasons or because they don't comply with the administration's objectives?
This is almost unheard of. Sure, if someone is taking a grant and they're not doing the work, they get cut off. But the notion that we wouldn't have given this grant, so we're simply going to cut it off, is extraordinarily wasteful, and administrations of both parties in the past have refrained from doing it.
Explain the Supreme Court's ruling, which was 5-4.
The question came to the Supreme Court whether to stay, whether to suspend the order that the district court judge had issued. And the district court judge did two things. He struck down the policy guidance the administration based its terminations on, and it struck down the terminations itself. 4 justices, the 3 liberals and the Chief Justice, voted to deny any interference with the district court's order, to let the court order take effect. 4 justices voted to stay the entirety of the court order, and the deciding vote was cast by Justice Barrett, who said that she wanted to stay the resumption of funding, but would not interfere with the finding that the policy guidance was illegal.
And what was the reasoning of the majority in allowing the government to withhold the grant money?
Their reasoning was that anyone who'd had their grant cut off should have gone to the Court of Federal Claims, not federal district court. And that's the place that it is proper to pursue debts from the federal government.
Will you explain why Justice Barrett came down differently on the NIH cutting the grants and on the policy?
Justice Barrett held that the federal district courts are completely proper places to challenge the legality of guidance that is issued by the administration. So if the challenge is that this guidance is without solid legal basis, that it's contrary to the federal government's legal obligations, that it violates civil rights laws, those are proper claims to bring in federal district court and to get an injunction, she said. But she said that if you actually want money, that has to come from the Court of Federal Claims.
So that means that the challengers here would have to go to 2 separate courts and bring 2 separate actions?
Yes, she said there's precedent for that, and she asserted that that was the result of Congress's passing the jurisdictional statutes they have and the Supreme Court's prior interpretations.
The Court of Federal Claims is, to say the least, not well known. Do you think Barrett and the other 4 conservatives were right about its jurisdiction?
No, I don't. The Court of Federal Claims is there to handle a lot of routine matters where there's a question about the quality of the paint job that was done on a federal office building and the federal government's refusing to pay and the painting contractor wants to be paid. There's a need for that, but that's very different from a systematic violation of thousands of contracts asserting a power that has never previously been recognized. Those are the kinds of statutory and constitutional issues that have long been the province of the general federal court system, the district courts and the circuit courts of appeal.
Can the groups here, now that they have this decision on the policy, can they now go to the Court of Federal Claims and get the money?
If only it were that simple. This was not a decision on the merits of those policies. It was simply about how the litigation should proceed. And Justice Barrett, joining with the Chief Justice and the 3 liberals, held that the litigation can continue in the First Circuit Court of Appeals about whether or not those policy documents are legal. And if they are struck down again in that court, the Trump administration could appeal back to the Supreme Court on the merits. She indicated that there were some open questions in her mind that would need to be resolved before a final decision could be made about the legitimacy of those policy documents. So she was only keeping the litigation alive. She wasn't resolving it in the favor of the challengers.
And the majority found that the government would be irreparably harmed if it had to pay out this money? How so?
Yes, that's a particularly disturbing part of it. They said that because the recipients wouldn't be able to repay the government if it was ultimately found that the money was not owing, that the federal government shouldn't have to pay out the money until after a final judgment is issued, which, once appeals are accounted for, could take several years. This is treating the entire matter as a debt collection issue rather than an issue of democratic governance. It could be that at the end of the day, the parties entitled to money will get some money, but the research will long since have been abandoned The employees long since have been laid off. Many of the nonprofits will have been bankrupted by the long delay. And this is essentially saying that the federal government is too big to comply, rather than too big to fail, too big to comply, because the size of the grants it gives out and the importance of the grants it gives out are such that the recipients don't have the money to pay it back.
Justice Neil Gorsuch sort of scolded the lower court judges here for not following the Supreme Court's emergency ruling in April that allowed the Trump administration to cancel $65 million in teaching grants. Quote, lower court judges may sometimes disagree with this court's decisions, but they are never free to defy them. He also complained about two other district courts not following Supreme Court rulings. Quote, so this is now the third time in a matter of weeks this court has to intercede in a case squarely controlled by one of its precedents. But he's referring to rulings on the shadow docket where there aren't full briefings or oral arguments or sometimes even opinions.
Well, it's a very curious position they're taking. Most of the history of the Supreme Court has been through formal consideration of cases, oral arguments, briefs, and thorough opinions from the justices. Increasingly, under the first Trump administration, the Biden administration, and now the Supreme Court is not accepting full briefs, not listening to oral argument, not writing full opinions, sometimes not writing any opinions at all. And what Justice Gorsuch is saying is even when the Supreme Court is issuing an emergency order, and even when it's not at all clear what the basis for that order is, the lower court somehow must read the Supreme Court's mind. If the Supreme Court wants lower courts to follow it, it needs to tell them what it's doing.
Chief Justice Roberts joined the liberals in the case involving the teaching-related grants and in this case. Is that surprising in any respect?
No, Chief Justice Roberts has been very concerned about business climate and allowing businesses to function freely. And a federal government that isn't bound to comply with its contracts is very bad for business. Throughout the country's history, contract has been a central part of its law, and the notion that the government, above all, complies with its contracts has been central. We have a new administration that doesn't want to, and rather than bringing it to heel, this court is bending over backwards to accommodate it. If I were a private business person, I would be doing anything I could to avoid having to contract with the federal government because the effect of these decisions is that the contract isn't worth anything.
Is there any other avenue that the researchers and the organizations and the states can pursue, or is it just the Court of Federal Claims?
They can go to the Court of Federal Claims. There are significant obstacles to getting relief from that court. It's a real court. People do win real judgments there. I don't mean to disparage it in that way, but it's going to be a very difficult way to proceed. Lots of money that is owed probably will never be ordered to be paid out of that court. And the result of all of this is likely to be that many of these programs are indeed disbanded.
Between this decision and the April decision, it's not good news for those who have grants.
This isn't really a liberal or conservative thing. This is just a rule of law thing. And if the government doesn't have to keep its contracts, no one should do business with it.
It's always a pleasure, David. Thanks so much. That's Professor David Super of Georgetown Law. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news by listening to our Bloomberg Law podcasts. You can find them on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso. Stay with us. Today's top stories and global business headlines are coming up right now.